Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. One thing that we've been seeing in the courts is unvaccinated jurors being excused from jury duty and so sent home. And this is potentially a trial fairness issue. Regardless of your thoughts about vaccination, this is potentially a concern as to whether the courts are going to be in a position to deliver a fair verdict. So let's have a look at one of these cases and I'll talk about it as we go. So this is the case of the Queen and Esser Jose, and this is a very recent decision. You can see it was filed February 1st, 2022. I hope I've got that name right, but they never include pronunciation guides in court cases. So this, what was going on here is they were doing jury selection, and jury selection, basically they send out jury notices, and lots of people are required to attend for this, but only a small percentage of those people are actually going to become jurors. So that's kind of what's going on here. Now, when they arrived, everybody who was not able to show that they were vaccinated was sent home. So I'll read from the case here. On Thursday, January 27th, 2022, 3 juries were selected at the Bonaventure Writing Center in Edmonton, Alberta. Despite the fact that 3 individual justices had been assigned for trial, Little selected all 3 juries. Those jurors that responded to their summons to attend were checked in by the clerks, who also checked that each prospective juror had a QR code showing that they had received at least 2 COVID-19 vaccines. Those who did not show proof of at least double vaccination were excluded from joining the jury pool. Defense counsel advised this court that he was not aware that unvaccinated individuals were to be excluded from the jury pool until he attended for jury selection. He discovered this through casual conversation with others. Upon searching, defense counsel found a notice to that effect on the jury summons response form on the Alberta Queen's Bench website. There was no notice to counsel of any kind. So let's bring up what that says here. The Court of Queen's Bench is taking precautions to protect your health during the jury selection and trial process to minimize the risk of transmission of COVID-19. You may be provided with a medical mask and be required to wear the mask unless you are exempt from these requirements. You will be required to produce your Alberta-issued COVID-19 vaccine record with the QR code. Voluntary rapid COVID-19 testing will be available and will be conducted by qualified professionals. If you have symptoms of COVID-19 in the days leading up to jury selection, do not attend the jury selection, and you must call your local courthouse prior to attending. You must also call the number on your important information form after 2 p.m. on the day before the jury selection date appearing on your summons. A recorded message will let you know if you are required to attend jury selection. So this is on a form for a juror, a prospective juror, in response to that summons. So you get a summons, which is a court order saying you must show up for this jury selection. And in fact, if you just blow it off, they can proceed to take legal action against you. It's a pretty serious thing. And the reason why they have it where it's actually a summons with legal obligations is that we really want to get a representative sample of the population, not just the people who felt like showing up. So in terms of notice here, counsel wouldn't normally be checking these forms. This is a bit of an unusual sort of issue here. So let's jump back to the case. Before jury selection began, defense counsel sought an appearance before the presiding justice and objected to the process and to the exclusion of jurors who were unable to show proof of at least 2 COVID-19 vaccinations. The presiding justice continued with the jury selection process after determining that the accused had a right to be tried by his peers, not his unvaccinated peers. However, the presiding justice advised counsel that he could renew his objection before the assigned trial justice. Defense counsel objects to the jury selection process for 2 reasons. 1, the jury selection process was tainted by an ultra vires exclusion of jurors. So ultra vires means outside the power of the court. They are exercising authority that they simply don't have, is the argument there. And 2, the exclusion of jurors was done without notice to the parties by administrative fiat. As a result, there has been a violation of natural justice and the accused charter rights under Section 7, 11D, and 11F. Defense counsel initially sought a mistrial, however, now seeks an adjournment as his remedy. So basically, instead of a mistrial, what they're saying is probably an adjournment and a new jury selection. So argument. Defense counsel provided the recent decision of the Queen and Aiello. In that case, after inviting counsel to argue, the court, on its own motion, excluded unvaccinated jurors from the potential pool. Justice Devlin relied on Section 632C of the Criminal Code, which we'll cover in a bit later here, and at paragraphs 12 to 17 cited multiple reasons for the exercise of his discretion, ranging from public health concerns to trial fairness. Defense counsel also provided other cases dealing with similar exclusion orders after notice to counsel, including the Queen and Morales, the Queen and Roche Garcia, and also similarly the court in the Queen and James followed the procedure of holding argument on a motion before the court, but decided not to question the jury pool regarding vaccine status. So these are all cases regarding essentially, should there be argument before the court exercises this discretion. Defense counsel asserts that the perfunctory exclusion of those potential jurors who are unable to provide proof of vaccination, as he says is the case here, does not convey such proper exercise of discretion and is therefore not supported by Section 632C of the Criminal Code. He cites the Queen and Smith as an example of the dangers of unintentionally affecting the makeup of a jury. In that case, defense counsel asked the court to use their standby power to set aside qualified prospective juries in order to ensure that the final member of the jury was black. That decision outlines the history of the development of Section 633 and Section 634 and changes to Ontario's legislation that were made to remove systemic barriers and ensure representativeness in the jury pool. Broadly, the decision reflects the desire to ensure that the court's standby power will not be used to improperly defeat those ideals. The court noted that, potentially, orders requiring COVID-19 vaccination could possibly do such a thing, and if exercised improperly, judicial discretion could unintentionally affect an accused's constitutional right to a fair trial by an independent and impartial jury. The key issues, defense counsel argues, are the independent exercise of discretion of the justice to determine whether or not to exclude unvaccinated jurors, and further, that fundamental justice requires notice to and submissions from counsel to be part of that process. So this is a big deal here in terms of a procedural and trial fairness issue, because what defense is saying happened here and what appears to have happened is that the justice made this decision to exclude unvaccinated jurors without asking counsel to make submissions or giving them the opportunity to tender evidence, which they might have done. And certainly if I were making such an application, I think some evidence would be very useful here. You might need some social science evidence, for instance, expert witnesses. But this is potential, normally we have this adversarial system because you want both sides to be able to argue their point. And it might be that the sides would say, listen, in this trial, we just don't care. Go ahead, exclude them. That's fine. But they might say, listen, for this particular trial, it's a big deal because it might matter somewhat what kind of trial it is, what kind of issues are on the go. And, it might matter what counsel thinks makes most sense here. It may be that, counsel on one file is in possession of some knowledge that suggests, hey, this could skew the jury in one way or another. And particularly, we say that we want to weigh things in favor of acquittal if we're going to make an error. Better that 10 guilty men go free rather than one innocent be convicted is a sort of common maxim. And so you want to be careful to avoid potentially putting your thumb on the scale by picking an unbalanced jury or a skewed jury that might be in favor of conviction over the general public. That's, you don't normally want the justice just making decisions based on their own personal thoughts and feelings. Counsel should be heard. That is normally a fairness issue. So the court continues here. Absent the specific application of Section 632C, defense counsel argues that there is no other authority for the broad exclusion of potential jurors who are unvaccinated. Defense counsel relies on Section 5 of the Jury Act, and this is Alberta legislation, which has a bunch of provisions for exemption from jury service. And I'm not going to go through all of them, but I will give you some examples here. So the following persons may be exempted from serving as jurors: a person whose conscience or religious vows preclude the person from serving on a jury. Some religions say, listen, you're not allowed to stand in judgment of another person, and they take that real seriously and won't do it. So those people can be exempted from jury duty. A person who has served on a jury within the 2 years preceding the person's summons to serve on a jury. Jury duty kind of sucks. It can really disrupt your life. It can disrupt your work. Often people are not getting paid during this time. And so we want to limit how often somebody gets essentially the short end of that particular stick. A person for whom it will cause severe hardship in respect to their person's health or livelihood, or in respect of any legal or moral obligations the person may have to others. So let's say you need to be, you're on dialysis. You got to be connected to a machine every so often. They may exempt you on that one. Or if you are a small business owner, you're the only person who runs your store, you can't go to and sit in a 3-week fraud trial because your business is going to be done by the time you get back. All sorts of things, so that's, some issues there. There's other things about a person who's unable to understand, speak, or read the language of which a trial is conducted. These kinds of aspects here. So on application, in the prescribed manner, if a sheriff, so this is actually a sheriff who makes the decision. It's one of the rare circumstances where you've got a sheriff acting kind of as a judicial decision maker. That's a little bit interesting and odd, but that's what's in the law. If a sheriff is satisfied that a person is eligible for exemption under subsection 1, the sheriff shall exempt the person from jury service. If the sheriff refuses to exempt a person, that person may either A, on application, prior to the date on which the person has been summoned to attend for the selection of the jury, appeal to any judge, or, at the time of the selection of the jury, appeal to the judge that is presiding at the jury selection. So if the sheriff says, I don't think your exemption reason is good enough, you can actually go to your jury selection or prior to it and have that heard by a judge. So there is an appeal from the sheriff, because again, it's kind of odd that the sheriff is acting in this judicial role, but that's the way the legislation is written. So defense counsel argues that this section does not give the sheriff discretion to exclude anyone based on the sheriff's initiative, nor does the section allow the court as an administration to do so. Defense counsel argues that this section permits only the individual juror to make an application to be excluded. As such, the only authority for a presiding judge to exercise discretion to exclude is section 632 of the Criminal Code. Since potential jurors who could not provide proof of at least 2 vaccinations were dismissed by the clerk, the jury chosen to hear this trial was improperly constituted, and as such, there's no jurisdiction for a trial before them. Defense counsel cites Morin and the Queen to support this position. So essentially, this is a provision that allows the juror to say, I've got a problem with this. So notwithstanding the fact that somebody might actually fit within one of these categories, for instance, a person 65 years of age or over, they might say, you know what, I kind of want to be on the jury. And so notwithstanding that it's may be exempted from service, because this is a may, not must, there are other provisions that say that you must be excluded. For instance, myself, as a member of the bar, I must be excluded. I am not permitted to serve on a jury here in Alberta. But, a person 65 years of age or over might not want to be excluded, and so they don't have to make that application. So essentially what defense is saying is the court can't do this on its own motion. The sheriff can't do it on its own motion. And if they purport to do so, then they're acting outside of their authority, and that makes this whole process invalid. And because the process is invalid, this group of people that you've got here as the jurors aren't a real jury. They don't actually have, they're improperly constituted. They have no authority to make any decisions in the court process. That's just to sort of walk through the argument that's being made here. So defense counsel also argues that this court's failure to give proper notice to counsel about this change in policy breaches principles of natural justice. He argues that if a jury selection process does not comply with statute or provide counsel with a fair opportunity to respond to proposed changes to ensure a fair and transparent jury selection process, Section 11D of the Charter is breached, and the only remedy is a mistrial. In this case, as the application was made before the accused was arraigned, an adjournment is sought. So basically, because they're not yet at trial, they can't mistrial. They've got to ask for an adjournment here. That's sort of the distinction there, at least I think. There's not a whole lot of detail that wasn't a key point here. So responding argument, this is what the Crown is arguing in response. And, so they say the Crown argues that, however late in the day, fair and accurate notice was given to defense counsel of the plan to exclude unvaccinated jurors. The Crown urged the court to consider the context of the ongoing global pandemic. Following a suggestion by this court, the Crown argues that, in order to provide a factual background for the jury selection that occurred in this case, judicial notice can be taken of the current state of the pandemic in Alberta, drawn from the Alberta government's website. In the context of the ever-changing state of the pandemic, extensive notice to the profession is not reasonable. So essentially they're saying, listen, we keep learning new things about this pandemic. We can't give notice of what we're doing every day because the rules keep changing, and you got to follow up on the webpage to find out what's going on. And when they're saying that the court can take judicial notice of the pandemic, judicial notice is kind of a weird thing. Normally, for the court to consider anything, it's got to be in evidence. So some side has to bring evidence of a point. And the only place where you can really get around that is when the court can take judicial notice of sort of obvious facts. And so, for instance, let us say we have a basic case of, somebody is alleged to have defrauded somebody, and they did some math and they put $1,000 plus $1,000 equals $1,500, and so they deposited $1,500 in the bank on behalf of the company and then pocketed $500. You wouldn't be able to go to the court and say, listen, we don't have any evidence from a mathematician that this math is weird. The court can just take judicial notice of the obvious fact that $1,000 plus $1,000 makes $2,000, not $1,500. These kinds of obvious things, it would really bog down the court if we had to, take judicial notice of the fact that, you could get cut by a knife or these kinds of things. And so this allows the court to basically say, this is obvious, it's not a contestable fact. But where you've got something that is potentially more contentious, then that's an issue where you might want experts. I think that it is probably within the court's realm to take judicial notice of the fact that there is a pandemic going on, but possibly not if you start talking about questions of seriousness of it or that kind of thing. But again, I say only possibly not. I'm not going to delve too much into that because, yeah, it's not what this video is about. And I don't really want to branch off into 16 different topics here. So in the alternative, the Crown argues that if there was insufficient notice to defense counsel of the court's decision to exclude unvaccinated jurors, curative provisos of the criminal code can be applied. So what this means is the curative provisos in the criminal code essentially recognize that sometimes there's going to be mistakes in court decisions, but that not all mistakes are created equal. Some mistakes we can get around just by, maybe a jury instruction or maybe just not doing anything at all. You might say, okay, this was a mistake, but it doesn't actually result in any harm or any, prejudice or any difficulties like that. And so we're just gonna move on and say, okay, well, yeah, there was a mistake, but the result is we can fix it doing something else. So that's essentially what a curative proviso is we don't have to have a new trial or a mistrial or anything like this. We can fix it with some sort of consideration, or maybe just by doing nothing. All right, so the continuing on, the Crown argues that there is no evidence to suggest that the jury pool was not representative after potential jurors who could not provide proof of vaccination were exempted. Now, this is kind of interesting because normally in order to provide evidence for something, you'd need some notice. So that's kind of it. To me, it kind of ties all together, the notice and, so forth. Now, I don't actually know here. Actually, maybe I can just scroll up in the case here. So we've got January 27th, 2022, which is when the jury selection is done. And the actual case was heard February 1st, or the decision came out on this. So in terms of time to get evidence together, you got a real narrow time frame there, especially when we're starting to talk about, as I said, this is a potential issue for social science expert evidence. People who can do surveys of pools of vaccinated people and unvaccinated people to see if maybe they have some key differences on, whether or not they have the same racial makeup, whether they have the same religious makeup, whether they have the same makeup in terms of other beliefs that may be relevant to a jury process. So the no evidence aspect, to me, ties in and connects to the notice issue. All right, so analysis here. I'm not going to go through the full analysis, but I'll give you enough to get a full overview here. I don't want this to be an hour-long video. Yeah, I want to try to keep this short and punchy, so I'll carry on here. In Barak, the court found that there was no evidence that as a group, unvaccinated people shared any common thread or experience that would not be brought to the jury process by only vaccinated people. The court ultimately focused on the issue of whether the exclusion of unvaccinated people from the jury pool could be characterized as exclusion of a particular group of people, and whether their exclusion breached the accused Section 11 charter rights. That's trial fairness and, those sorts of rights. Drawing from previous challenges to the exclusions of non-citizens, the court found unvaccinated people and non-citizen people to be analogous. So that's kind of weird. I'll come back to that. The court was unable to find characteristics unique to a group of unvaccinated people that was relevant to jury duty, and as such, the order excluding those people during an ongoing pandemic was not a charter breach. So they're drawing a parallel, an analogy here between people who haven't been vaccinated and people who aren't citizens of Canada. I think that's a hell of an analogy. I would not make that analogy myself if I was on the bench. That to me seems problematic. But again, they're saying there's no evidence that as a group that they share any common thread or experience. Well, let's consider just a little hypothetical here, because this case, from what I understand, was how do I put it in a way that YouTube won't get upset? This was a bad touching case. And just as a minor rant here, YouTube's censorship or, demonetization of any sort of term they don't like ends up kind of being really forgiving of people who have been accused of serious offenses. Because, bad touch sounds a lot less serious than the actual offense name. Similarly, when I did a video, the Twisted Tea Smackdown video, it's kind of really forgiving to the guy who was sort of the aggressor in that one, when you have to bleep out the guy dropping the hard R N-word. It makes it, it makes him seem like less of a jerk. So yeah, that's its own rant. Anyway, but yeah, as I was saying, this is a bad touching case, but let's consider that this jury trial results from a fight between people over somebody not showing their vaccination status when they're going into a restaurant, and getting into a fight with the person working at the front of the restaurant. And whether it's the employee there who's trying to check vaccination status, or the person who is showing up and refusing or unwilling to show a vaccination status, regardless of who's charged, there is a potential that, the unvaccinated jurors may view the interaction differently than vaccinated ones. Just kind of a thought on that one. So, yeah, it's... I'll carry on here. They say, it is accepted that prior to court opening, jurors were screened for proof of vaccination, and those that did not provide it were released from jury selection. After roll call of the remaining jurors, defense counsel raised his objection to the procedure in the absence of the pool. Having little notice, defense counsel did not explicitly argue the issue of the presiding justice's discretion, as he has in the application before this court. Yet he did articulate his position that, given the screening that took place, there was no jurisdiction of that court to select a jury at that point in time. And so the justice made the following ruling, and this is an unofficial transcript because of the close timing. They were actually using the audio recording rather than a sort of officially prepared transcript. But the court says, the court has an obligation to protect the public, including those who are called for jury duty. The court has made a decision to ensure the vaccination status of the people who are here so that everybody is protected. A decision that's made by other institutions and businesses. In my view, it is a reasonable restriction on your client's right to be tried by a jury of his peers, a right to be tried by a jury of his vaccinated peers, which happens to be a larger portion of the population in any event. So I got some issues with this particular reasoning because what he's saying is, I'm only excluding a minority. And if you pick any other minority, this is like, if you try to apply this reasoning in an analogous fashion, it gets you into real ugly places real fast. So, saying, oh, well, we're just going to go with the majority here. Ooh, I don't like that argument at all. But I mean, there is a question of whether or not there is a real distinction there in terms of, charter protected interests or the like. But I really don't like the reasoning on this. Yeah. So the presiding justice then immediately attended to jury selection, and in his initial address to the pool said the following: "Nothing would be complete without reference to COVID-19 and the extent to which we are making efforts to protect you. You know that one of the protocols this morning was that you were screened for a QR code or some sort of proof of vaccination, so you can take some comfort in knowing that the people you are sitting with have been vaccinated." All right, and they say, counsel is likely correct that the exclusion of jurors based on their vaccination status must be made an exercise of the presiding justice's discretion. Our Jury Act is different than the one in Ontario, and the powers to exclude are not as broad here. The Alberta Act includes the following provisions, and so sections 3 and 4 describe qualifications of jurors and lists of those that are excluded, and section 5, the one we've been looking at, lists those who may be exempted, so where it's a discretionary application. So regarding a justice's discretion, section 10 of the Jury Act states, at the time of the selection of the jury, the judge may, and section B is, direct the discharge from the jury panel of any person who the judge is satisfied is not qualified or is excluded. And then section 632 of the Criminal Code has excusing jurors. The judge may, at any time before the commencement of a trial, order that any juror be excused from jury service, whether or not the juror has been called pursuant to subsections 631 sub 3 or 3.1, or any challenge has been made in relation to the juror for reasons of, and the most critical one here is subsection C, personal hardship or any other reasonable cause that, in the opinion of the judge, warrants that the juror be excused. So this is a broad blanket clause, any reasonable cause. So it's open to the court to say, hey, you know what, we find that this is a reasonable cause. And they say, relying on these sections, the presiding justice had the discretion to exclude from the juror pool those who, in his opinion, should be excluded for reasonable cause. Doing so aligns with Aiello, released months ago in the same jurisdiction, as well as Thornhill and Barak. And I quoted the bit from Barak, I didn't go over the other ones. Conclusion. Regardless of any policy of the court, the presiding justice in this instance clearly exercised his statutory discretion and excluded unvaccinated jurors for reasons of public safety, with consideration, albeit brief, of the accused's rights to be tried by a representative jury of his peers. This was done with extremely limited notice to counsel. And they say this jury selection was therefore not without jurisdiction. In the context of the above, and considering the competing interests at hand, there was no breach of the accused's charter rights by the manner of the jury selection and the exercise of the presiding justice's discretion. If the issue is of limited notice to the accused of the court's intention was in fact a breach of the accused's charter rights, no remedy is warranted as no prejudice occurred. I'm going to address that in a second. A procedural irregularity does not in and of itself create prejudice. No evidence has been offered and no argument made regarding prejudice as a result of the exclusion of unvaccinated jurors or as a result of the limited notice of the decision of the court. The application of defense counsel is dismissed, the jury will be sworn in, the accused then arraigned, and then he will be placed in the charge of this jury. Okay, so, let's break this down a little bit here, because they say, no remedy is warranted of limited notice because no prejudice occurred, and we know no prejudice occurred because no evidence has been offered as to the result of the exclusion of unvaccinated jurors. But the no evidence being offered may itself be the result of that prejudice, because how are you going to get the sort of necessary evidence together to argue that there is prejudice if you've got notice of, 0 days on the first instance, and what is it, less than a week in between that, it seems to me that this is very difficult. Now, in terms of my own legal analysis here, in terms of how I would handle this, um, I think that there is potentially a discretion for a justice to exclude unvaccinated jurors. But I say this, and I know I'm going to be making a whole lot of people in the comments mad. Feel free to let me know. But the, you know, one thing we always have to consider is that jurors are compelled to attend. This is something where you don't have any question on it. You're just issued a summons and you are required to attend. And some people are going to be, fearful of attending in a situation where, we have a pandemic. And we also have to consider that the principles that we are laying down in any sort of trial apply not just to their own facts, but are going to also potentially set down principles for other cases. We need to make decisions based on good principles because of that possibility that they apply to future cases. So let's consider that we have, so far the variants have been at a lower level of lethality. But let's say we consider that a new COVID variant comes out and it's 80% lethal. Something that gets us into civilization killer range of diseases. Certainly, I would not want to show up for a jury if there was a disease floating around that was like as lethal as Ebola. If we just consider this, I think that there is a potential for a justice to make that decision on a discretionary basis. But I think that the proper exercise of any judicial discretion has to be with notice enough for people to, to address the issue, and with the opportunity for counsel to make submissions. And submissions in this case have to mean that they have the opportunity to and time to bring necessary evidence, because, the court is dismissing this in large part on a lack of evidence. So I think that there is prejudice here. It seems very difficult to get away from that. Now, in terms of how this might be litigated by the courts in future, you may see a future case where, somebody brings to the jury selection this evidence and they say, listen, I want to make an application ahead of time to say that this should not happen. And here's why. Here's the evidence I'm bringing. We haven't seen that case yet, and it'll be really interesting. As I said, not all cases are going to be equal on this, but there is a very real possibility that that some groups are being excluded here. We don't have the evidence in terms of the social science, but I have seen commentary online, and I'm just going to say, I'm not an epidemiologist. I'm not a researcher here, but when we see things about lower vaccination numbers among certain populations, whether those are religious splits or racial splits, that's a potential concern, because if we are excluding, a particular ethnicity more than we're excluding another ethnicity, then we're talking about real concerns as to the validity of this, of this process. We're talking about possibly, shaping the jury in ways that would never be permitted otherwise. So I don't like this decision in terms of the procedural elements. We can argue all day over, whether people like the vaccination issues, and I'm not a doctor. I'm not an epidemiologist. That's not where I'm going to venture here. But in terms of how the court made this decision, I'm not super thrilled with it. So ultimately, we'll see. This one might actually be one that gets appealed in some form, and if that happens, I'll be really interested to see what what transpires. The court right now is being faced with a very difficult emerging situation, and as I said, I do have some regard for the fact that people are compelled to attend for jury duty. And, they're going to have a variety of different opinions and feelings about this. And it makes things very difficult in that sense. The other problem that I see with this decision is that, if we're excluding anybody who just doesn't show up with their, with their vaccination record, then we create a possibility for people to sort of have an out. And you shouldn't do this. Like, don't leave your vaccination record at home just because you don't want to get into jury, service. That could potentially be viewed as contempt by the court, and you never want to be held in contempt. But, it does create this real risk of people doing this intentionally, which is normally a behavior that the court cracks down on and does not want to permit, because we don't want to have a jury consisting solely of volunteers, because those volunteers may in fact be more willing to convict or to acquit because they might be doing so for other reasons. We want to make sure that the jury is a representative pool. So yeah, this is a tough topic. I know there's going to be lots of angry people in the comments. I can take it. If you're ticked at me, go ahead, but please be nice to each other. We're all trying to do the right thing in a difficult world here. And so please, don't get into fights you don't need to. There's enough stress and BS out there already. Anyway, thank you for watching. Please like this video. Please share it with your friends. Subscribe to see more content, assuming I haven't ticked you off here. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Firearms Association; Mike, Kyle Martin, the CCFR and the Canadian Shooting Sports Association; at the $30 level, Sights and Arms Limited and Marc-Olivier Damour; and at the $20 level, Peter Hilger, Mark Whittington, Jane Babe and Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delso. Thank you as well to the $10 supporters who will be in the crawl immediately following. And thank you for watching. I hope this has armed you with knowledge. And as I said, this is a really difficult topic because it's a very controversial issue with a lot of elements to it. Really, my main concern on something like this is fundamentally trial fairness. Are we getting trials that are fair, and especially fair to the accused? Because that is a critical cornerstone of our justice system, is that we are not that we're not having a trial. We would never, for instance, have a trial where the accused was being tried by like 12 close personal friends of the complainant. That wouldn't be fair. So this kind of thing worries me in terms of what it might do to accused, because let's say, for instance, you've got, a black accused, and if this happens to exclude more black jurors than it does white jurors, that's the kind of thing that the court would really take a harsh stance on. Anyway, as I said, thank you for watching. Hopefully you are not too ticked at me, and see you next time.